All rise. This Court of Appeals is now in session. The Honorable Jennifer Hensel presiding.
Good morning. Please be seated. The first matter to come before us this morning is State of Ohio versus Christopher Meadows. The state has waived oral argument. You have 15 minutes to do with it as you please. We have read the briefs and are ready to see from you away.
Thank you. Good morning, and may it please the court, your honors. My name is Jacqueline McCorgan, and I represent the appellant in this matter, Mr. Christopher Meadows. You have heard Mr. Meadows' appeal in the past. This is a murder case that comes before the court again as a reopened appeal pursuant to Appellate Rule 26. And we are here due to the allegation that Mr. Meadows' previous appellate counsel was ineffective for failing to ask this court to notice plain error in the trial court's denial of Mr. Meadows' motion to have the jury in his case instructed as to the lesser included offenses of reckless and negligent homicide. Now, I have raised 4 assignments of error in the briefs that I have done to this court, and with the court's indulgence, I would like to focus my argument today on assignments of error numbers 1 and 4, which deal directly with the issues of the lesser included offense instructions and appellate counsel's ineffectiveness. And I would like to submit the other 2 assignments of error regarding whether Mr. Meadows was denied the effective assistance of his trial counsel, and also whether his convictions are not supported by sufficient evidence. I'd like to submit those on briefs, unless the court has specific questions about those. Now, in regards to assignment of error number 1, the trial court did deny Mr. Meadows his rights under the 14th Amendment due process clause when it denied Mr. Meadows' request to instruct the jury in his case concerning the lesser included offenses of reckless homicide and negligent homicide. And this ties in with the ineffective assistance of appellate counsel part of the argument, in that, as the court is aware, I'm sure, that it had reopened this appeal on the grounds that previous appellate counsel had not argued that this was plain error. Basically, what had happened during the trial was Mr. Meadows' trial counsel had submitted a written request for jury instructions concerning the lesser included offenses. That motion was denied, but the trial counsel did not object specifically to the jury instructions as a whole prior to the jury retiring to begin to deliberate. Now, in the previous round of appeals on this, the court had noted that its previous precedent was that if a trial counsel does not object to jury instructions prior to the jury retiring, that waived any argument as to error on jury instructions. So the court had held regarding the motion for a reopened appeal that potentially would be ineffective assistance of appellate counsel. In order to show that, I have to show that there was indeed error, and I'm arguing to this court that based on Ohio Supreme Court precedents and this court's previous precedents, that this court can find that the denial of that motion to include those jury instructions could be either plain error or an abuse of discretion on the part of the trial court. The error, or such an error, is reversible if, again, Mr. Meadows were to demonstrate that the court abused its discretion in denying the request for those jury instructions, and that Mr. Meadows was prejudiced by the absence of the instruction. Of course, when it comes to jury instructions, the general rule is that a court must give all instructions that are relevant and necessary for the jury to do its function as a fact finder, and all instructions that are party requests, so long as they are accurate statements of the law and warranted by the facts. In criminal cases specifically, a court must instruct on all elements of the offenses, and specific to lesser included offenses, they have to instruct on lesser included where they are appropriate under the facts unless the instruction is waived. Now, the state has argued in its brief that a lesser included instruction regarding reckless or negligent homicide in this case would not have been appropriate, even if trial counsel had indeed objected to the jury instructions as a whole and under Ninth District precedents preserved the error. Well, the overall test for determining whether a lesser included instruction must be given, it's a two-part test. First, the court has to analyze the elements of all the alternative ways in which the offense can be committed. In this case, Mr. Meadows was indicted and tried and eventually convicted on murder or for murder under 2903-02A/B, and that's how it was put in the indictment and indeed, in all the subsequent forms, including the sentencing entry. Now, 2903-02A is, of course, purposeful murder, where somebody intends to kill someone else and has the specific intent to do so. 2902-03B is felony murder, in which somebody commits or kills someone while knowingly committing another felony. In this case, Mr. Meadows was also tried and convicted of felonious assault, which can form a predicate, a felony predicate to felony murder. So, one has to analyze the elements of both purposeful murder and felony murder. Now, in the second, I should back up. Under the elements test, to apply this to the facts of Mr. Meadows' conviction, basically all the elements of the offenses of negligent homicide and felony murder predicated on felonious assault do align. Each requires a death and a deadly weapon. And the difference between the two offenses is essentially culpability. Knowingly for felonious assault versus negligently in negligent homicide. Because the test is that you have to look at the elements and see whether you can commit the greater offense without committing the lesser offense. And that at least one element of the greater offense is not necessary for finding the person guilty of the lesser offense. So the elements do line up. You cannot commit felony murder with a gun, for instance, without committing negligent homicide when it's predicated on a felonious assault. Also, in the second part of the test, the court has to review the facts in the light most favorable, not to the prosecution, but in the light most favorable to the defendant, to see whether the facts are sufficient to support an acquittal on the greater offense and a conviction on the lesser offense. And if there's any reasonable view of the evidence that supports a lesser included offense instruction, then the court must instruct on that lesser included offense. So in that way, given the fact that an abuse of discretion is basically when you've got an unreasonable, arbitrary, or unconscionable decision not to include a lesser included offense instruction, we submit that this court would find that the trial court in this case abused its discretion in refusing to give the lesser included offense instructions that Mr. Meadows had moved for. Alternatively, if this court finds that indeed that Mr. Meadows' trial counsel did waive this argument and that it must be reviewed for plain error. Plain error, of course, being a deviation from a legal rule that's obvious and that affected the defendant's substantial rights, we submit that it also must be reviewed for plain error, and that plain error occurred in this case. Mr. Meadows was significantly and substantially prejudiced by the lack of this instruction. In a sense, the instruction the trial court gave concerning accident, which was not asked for by the defense, I think is an indication that that perhaps the jury, the facts supported a negligent homicide instruction, and that the jury could have indeed found negligent homicide if it had been instructed that it could do so.
So the accident instruction was in the jury's charge?
It was in
And your client did, or your client's attorney at that time, did not object to those written instructions?
He did not object to the accident instruction, no. And he actually did not object to the instructions as a whole.
Okay.
But he did not request an accident instruction. That was given by the trial court without request.
So what, I'm a little confused. I know what you're saying, but which instructions did he request?
He requested lesser included offenses of reckless and negligent homicide, and there were a host of other ones. There's an entire sheet of requests that he had made.
The reason why I got confused was, I think the state in their brief said that he didn't request those.
Oh, no, it's
Well, I know what you said, I know what you argued, but I'm just saying, I got a little confused. I don't know. It seems like maybe the state was also at one point responding to some things in the previous brief, maybe?
I think so.
So I got a little confused as to what was going on there.
On the same topic, I was under the impression that the defense asked for all lesser includeds, none of them specifically.
And maybe that was the difference that they were trying to differentiate between, that he did not specifically ask for particular ones.
I think the trial counsel orally during.
Well, okay, that would be in the transcript.
Right.
Okay.
The motion itself specifies 5 specific lesser included offense instructions that they wanted. There was voluntary
Okay.
manslaughter, involuntary, reckless homicide, negligent homicide, and aggravated assault. Oh, sorry, 6, self-defense as well. So the defense did request 6. And I think orally, I think that's what the defense counsel was asking for when he said, I'm asking for all lesser included offenses. I think he was referring to the ones that he had referred to in his motion. So I hope that's helpful to the court.
It's just that when the trial court then, so he filed a written motion, but then the trial court asked counsel during, before the charge of the jury, which lesser included offense instructions he was seeking. He didn't mention reckless or negligent homicide in that portion of the record. I realized that he filed a motion regarding that, but I think that's where the confusion comes in. So, was there a written ruling on the written motion of what to include in terms of charging the jury, or was there a written motion and then we had this interchange on the record, and then we end up with an accident instruction and
It's the latter situation, because I didn't find a written response, from the court, no written order.
And of course, then we started to get into the facts and we started questioning you. You do have, and I can't remember the name, but you do have the one person saying they saw him standing over him with, standing over him after they heard the gunshots. Like he was standing over him, like he was shouting.
Yes, we do have that testimony.
And obviously the medical examiner's testimony.
Well, I would submit that the medical examiner's testimony is equivocal on that point, because we have one shot that seems to have a downward facing trajectory and another shot that has an upward facing trajectory. And there's no testimony by the medical examiner. Of course, that would be impossible to determine as to where the gun was and where the people were in respect to those wounds. So we have one person's testimony saying, I saw him standing over the body with the gun, but that wasn't, first of all, that wasn't at the time when the shots were actually fired. That was after both shots had been fired. And then And I think one of the people, it may be the same one, Your Honor, who said that after glimpsing that, the person ran away. So we don't have any testimony where anybody actually sees the shooter standing over Mr. Walker actually pulling the trigger at the time. And, nobody sees anything at the actual time of the shooting. It could have been that the person my client may have stood up after the second shot and just paused and ran away. But there's nothing that says that we saw him actually fire the gun at Mr. Walker. So I hope that's helpful.
Oh, I understand, there's no gunshot residue on the seat.
No, but again, also, this was in December. I don't think we have any testimony as to the condition of the clothing or anything of that nature.
And the gun was never retrieved.
The gun was never retrieved, no.
But it was in his hand when he was left running.
It was in his hand when he left running, that's for sure. And his testimony was that during the whole struggle on the ground, he was trying to wrestle the gun away from Mr. Walker. And that during the struggle, that's when the gun went off 2 times. And
Of course, if he had the gun, you could check it for fingerprints.
maybe, but if both of them had their hands on the weapon at the same time, that would be equivocal too.
Well, at least it would show that the victim had his hands on the gun. He could have tested for fingerprints, but I understand.
And reached the end of your 15-minute allotted time. Thank you very much for your argument today.
Thank you very much, Your Honor.
We will take the matter under advisement, issue a written decision as we know both sides, and we surrender our say.